and welcome everyone to the August WBA Compliance Corner video. This is our second video where Heather and myself update you on hot topics and happenings within the world of compliance. And we look to keep these sharp and quick and just focus on the facts and give you a quick update on those topics that are on our mind within the legal department. With that, we do want to provide links when they're available. And so if something is marked with an asterisk within this presentation, as we go through our PowerPoint, you'll see that means that there is a link associated with the information on that slide. And so in order to get that information, you can just check in the description below where we will have a hyperlink that will take you directly to the associated material. So with that, let's jump in and take a look at what we'll be covering in this video. On the second slide here, we have an outline for you of our topics. First is FDIC's supervisory guidance on multiple representment NSF fees. This is, of course, an issue that we've been tracking and reporting on for a few months now, and we'll cover FDIC's most recently issued guidance in that section as well. We also have some new cryptocurrency-related guidance. This section will include releases from the agencies regarding engagement in crypto asset-related activities and various considerations and information that the agencies have provided. Then we have releases on commercial real estate, including updated interagency guidance. And then lastly, we're just going to quickly cover some exam manual updates from FDIC and OCC. So with that overview, I am going to turn over to Heather to get started.
Super. Thank you, Scott. And the first topic that we're going to talk about today is that new guidance that was issued by FDIC. So just issued here this month, August of 2022. Guidance on multiple re-presentment NSF fees. And as Scott mentioned, we have talked about this before, written on it in exec letter, and it's actually a topic in this month's compliance journal. Because of the severity that this topic is, we did want to make sure that you were aware of this most recent guidance that was issued. So talking about re-presentment, I think we're all on the same page, but just to make sure that we are, this is a situation where you have a customer who had an item presented. There were not funds in the account, and so the item was returned non-sufficient funds, and there was a fee assessed. That particular item comes back again through either the ACH route or other just general re-presentment standards. That same item gets presented a second or maybe even a third time, and it gets returned again if there are not sufficient funds in the account. And then potentially a fee is assessed to that same item so that you can have one item receiving multiple NSF fees. And the FDIC is taking a new approach on this particular topic, and they're really scrutinizing banks' deposit account records, their contract, and making sure that those contract terms actually match what it is the bank is doing. FDIC is also looking at how banks are notifying customers of such a circumstance of when there is non-sufficient funds. How quickly are the banks notifying their customers of that fact? We've got banks that are calling customers. We've got banks that are sending out information notices through online banking or through their mobile apps. Various different ways for which a bank is contacting customers regarding non-sufficient fund balances. And so the takeaway from the guidance, couple things. We've got consumer compliance risk identified, where FDIC is saying, please make sure that your contract is clear to really represent when you're charging fees. And also the notice component of making sure customers are aware of the non-sufficient fund balance. FDIC is also saying be aware of third-party risks when you're working with your core processors, making sure those parameters are set accordingly to your standards. How are you tracking these different types of multiple representment items? Be aware of what those third-party risks are. The guidance also talks about litigation risk, and quite frankly, that's quite the scariest one overall. There have been class action lawsuits here in Wisconsin. Some have been dismissed, others have been separately settled. But the litigation risk is something that should make you act, if you've not already acted, to make sure that you've reviewed very carefully your contract language and your practice, and then your contact of your customers. The guidance includes mitigation risk practices. This is similar information than what they had sent out in April when they first reported upon this. There's also information about what FDIC expects banks to do if in your review of your contract you identify that you have a potential issue. And also then FDIC outlines its supervisory approach when they're in looking at this at a compliance exam. Scott and I have taken a number of calls on this particular topic. I know it was something that was discussed with members at the compliance forum most recently, and it really is fact specific. It really is a case by case scenario. And so make sure you take a look at your contract, reach out to Scott and I if you've got any questions, and make sure that you're aware of what that supervisory guidance is. So with that, Scott, I'll turn that back over to you.
All right, great. Thanks, Heather. So the next topic to talk about is cryptocurrency. And so crypto, of course, continues to be a hot topic. It's still relatively new and continues to evolve on a somewhat regular basis, as there's always new activities going on, new requests, potentially expectations from customers and what they're looking for or questions that they have of you. So with all those unknowns and inconsistencies in definitions, its treatment, and again, those types of activities, as the regulators start to issue statements and guidance, it's important to be aware of and track that. So that's what we have for you here. We have a host of them on the slide for you. And I actually want to start with a couple of the previous releases, those being from OCC and FDIC. So FDIC issued FIL 16-2022 in April, and OCC issued its guidance on cryptocurrencies actually back in last November. And these are some of the first releases that we've had from the regulators, and both were issued to address the potential risk of crypto-related activities. They acknowledge that crypto is dynamic and ever-changing. As such, as part of that, it becomes difficult to assess safety and soundness and address consumer protection and potential consumer harm that could result here. In short, both indicate that a bank should notify OCC or FDIC as appropriate prior to engaging in crypto-related activities. Both of the agencies have also given overall risk considerations and supervisory expectations and what you can look for as you look to consider potential crypto activities, again, depending on what the activity is, depending on what questions your customers might have or where you're looking to engage, so that you can appropriately work through what those risks are, appropriately work through what potential consumer risks or potential consumer harm may be present there and needs to be evaluated. Now, along those lines, more recently, we've had some new releases. First, FRB issued a letter similar to the OCC and FDIC releases, and that is FRB is stating as well that supervised banks should notify their lead supervisory contact at the Federal Reserve prior to engaging in any crypto-related activity, or in the event that you're already engaged, that you should look to notify the Federal Reserve promptly of that fact. Furthermore, FRB provides some additional considerations. Banks should look to evaluate the legal permissibility of these activities, applicability of any filing requirements that might apply, again, depending on what the type of activity is, whether you have adequate systems in place designed to identify, measure, monitor, control any risks that might be associated with the type of activity on an ongoing basis, if applicable. FRB does look to identify some potential risks as well, including those that might result to various technologies, overall operation, potential facilitation of money laundering. Of course, given the fact that crypto is difficult to track often, a lot of these assets, and potential consumer misinformation, as well as overall financial stability. So in short, again, given all these risks, given all these considerations, and these are there for you to look at and look through and consider as well, in addition to the types of activities that you may be looking at, FRB is primarily issuing this notice to make sure, however, that regulated banks do contact Federal Reserve if you are engaging in these types of activities, to provide a description of the type of activity that you're engaged in, information related to that, and really create this correspondence, this transparency, and this ongoing dialogue that you can have with FRB. And again, that goes for the other regulators as well, to be able to be most well equipped to deal with this new territory. And along those lines, FRB also provides that state member banks are encouraged to notify their state regulator prior to engaging in crypto-related activity as well. So just separately from all of these notices, make sure you're not only considering your federal regulator, but you're notifying DFI as well if you're looking to become engaged in this area. Couple other recent notices that are actually quite helpful from FDIC. So one of them is a advisory. This is specific to consumer harm and overall risk evaluation. Regarding consumers, the advisory really hones in on deposit insurance. So the applicability of deposit insurance, and FDIC looking to ensure that customers are not confused and that no misrepresentations are made about which products FDIC insurance applies to, such as crypto assets, for example, which FDIC deposit insurance would not cover. There's also a discussion regarding risk management and governance when dealing with cryptocurrency. And the advisory is helpful in that it provides a whole host of links that FDIC has gathered to other various issuances, interagency guidance, and resources that you can use when making these considerations and conducting these risk-based evaluations. Then lastly, FDIC has issued a fact sheet. Again, along those lines, this time specific to consumers and really designed to be consumer facing and address those misconceptions about deposit insurance coverage and whether coverage applies to funds through crypto companies. So again, this is a fact sheet. It really lays out and just specifically lists, this is what is covered. This is what FDIC deposit insurance covered. This is what FDIC deposit insurance does not cover, and goes through those crypto assets, crypto type activities, and other engagements that consumers might be working with crypto companies through. So again, take a look at both of those and consider that this fact sheet could be used as a resource as well at your institution. If you have customers coming in, because we hear it on the phone, we hear it from not only you that you're getting questions from your customers, but customers call us as well and say, are banks offering this? What are they offering? A lot of times they don't understand. They are just hearing about it and they might want to know more. So this is an opportunity to have a resource to give to them, give to your frontline staff to hopefully help answer those questions. And again, the goal here is to clear up any potential confusion regarding what is covered and what isn't by FDIC deposit insurance. So with that, we'll move on and I will turn it back over to Heather for slide 5 here.
Super. Thanks, Scott. And indeed, to Scott's point, that fact sheet is a very helpful consumer-facing tool. So be sure to take a look at that in addition to the advisory. So Scott and I also wanted to make sure that you were aware of some recent issuances by the agencies regarding CRE or commercial real estate loans. And we thought that this information was helpful because sometimes when you see a pattern of different agencies issuing similar topics, it's kind of a show of hand of what they're looking for and what they're kind of concerned about. And, clearly as we are continuing to go through the outskirts of the pandemic recovery, lots of concerns over, are we in a recession? Is a recession coming? What's the economic downturn going to be looking like? Obviously, regulators are starting to look at risk. And I know some of you are saying, well, Heather, this is a compliance call. But many of us also wear the hat that is risk. And so there are 3 items that Scott and I wanted to make sure that are on your radar as it relates to risks and management of commercial real estate loans. And on the left-hand side, you'll see that there is an interagency policy that the agencies are looking to update. And Scott and I are currently researching this for filing comments on this particular update. It deals with prudent CRE loan accommodations and workouts. And this particular policy statement in the past has been very helpful, actually, for lenders when they are trying to work with their loan customers through a downturn or through a repayment struggle. And so what the guidance is looking to do is to update the current CRE workout options that are within that statement and to include a new section for short-term loan accommodations. So Scott and I, in our responses to the agencies about the revisions, we'd be curious to know whether or not you think that these updates or this new section is in fact helpful, or is there something that has been missed, or are they too narrow in what they are suggesting as being revisions to that policy statement. The comments are due in October, and so please feel free to reach out to Scott or myself with specific questions or specific input. And if you're not the particular person at your institution that has CRE risk management as their component or principal management responsibility, feel free to share the policy statement with that person and ask that party to reach out to Scott and myself. We'd be happy to collect their thoughts and their concerns as we create a response. So in addition to that particular revision, Scott and I also wanted you to make sure that you were aware of two other resource issue items that were issued. One being an article that was recently included in FDIC Supervisory Insights from this summer. And the other one being a webinar that was conducted here just recently, back in July, through Ask the Fed. And if you're not familiar with Ask the Fed, there are actually a number of different very helpful webinars that the St. Louis Fed hosts, and you can find it from the link that we've got included to these materials. But both of these resources really do give helpful background information, what the agencies are seeing for particular trends. And then you can compare that information with what's actually within the bank's own CRE portfolio and what strengths or potential weaknesses you might identify based upon what FDIC and the Fed are reporting on. So really good resources on the particular topic. So with that, Scott, I'm going to turn it back to you on the manual updates.
Great, sure thing. So on our last topic here, just a really quick update, because we do like to keep you updated when there are exam manual updates that the agencies issue. And so here we have just a few of them. We've got 3 from FDIC. The first one being updates to its risk management manual of exam policies, including updates to examiner instructions for offsite review and requesting information from the bank. And with those procedures, again, continuing to be offsite, those updates are helpful. Also, FDIC's trust manual, primarily for organizational purposes, and its enforcement actions manuals to overview and administrative matters and cease and desist actions. Then just lastly, the fourth one we have for you here, OCC has issued the 2022 edition of its annual bank accounting advisory series, and the updates for this year include updates to certain accounting standards. And as we look to wrap up here, I did want to share this slide. Heather and I have gathered some resources for you and wanted to let you know that we recently updated the compliance page on the WBA website, which now includes some additional tools, resources. There's frequently asked questions. There's a question of the month on there. And so we plan on keeping this updated and fresh for you. So make sure to take a look at it if you haven't already, and keep an eye on that as a place for going to check for your compliance resources. Also, if you haven't already perused the website, take advantage of the various publications and other training opportunities that continue to be available on there. And of course, don't hesitate to call or email us directly if you have any questions. If you have any questions about what's on the website, something that's not on there, or if there's just a situation that you want to talk to, don't hesitate to pick up that phone and call us at 608-441-1200, or if you prefer, or you want to type something out through email, you can reach us at wbalegal@wisbank.com. So thanks again for joining us, everyone, and we'll see you again next month.